Hi, everybody. I'm Brittany Lewis, a breaking news reporter here at Forbes. Joining me now is Forbes senior contributor Adam Minsky. Adam, thank you so much for joining me.
Thanks for having me, Brittany.
As you know, the Supreme Court began hearing oral arguments over President Biden's sweeping student loan forgiveness plan. What do we need to know?
Well, so the oral arguments were yesterday. They were pretty intense. And ultimately, I think it's anyone's guess as to how this ultimately ends here. A majority on the court did seem to express varying degrees of skepticism about the Biden administration's authority to enact this type of student loan forgiveness initiative. That being said, there also was significant discussion on the issue of standing, whether the parties that brought the suit are able to demonstrate an injury sufficiently connected to the program that would allow them to contest it. And that issue could potentially be really critical to whether the program is ultimately upheld or not.
Before we get into the nitty gritty here, there are two challenges. Can you describe them both for us?
So there are two challenges. One is brought by a coalition of Republican-led states, which are arguing that the administration's program will deprive the states of revenue because it will effectively encourage borrowers who have federal loans issued through an older program called the Family Federal Education Loan Program, or FELP for short, which are older loans that are issued by private entities and guaranteed by state-affiliated nonprofit agencies. Their argument is that it will encourage borrowers with those types of loans to consolidate those loans into the government's direct lending program. They argue that that will harm financially FELP agencies, which in turn will harm the states because of the states' relationships with those state agencies. The key agency here for this particular case is MOHELA, based in Missouri. The second case involves two borrowers who claim that they don't benefit enough or fully from the program as it was drafted. One borrower would be eligible for $10,000 in loan forgiveness rather than $20,000, which is the maximum amount, and the other borrower wouldn't be eligible for any loan forgiveness under the eligibility rules. They argue through their organization that's representing them that the way this program was established under emergency regulations prevented them from being able to participate in a public comment period, and they're arguing that that was harmful and that renders the program illegal.
Adam, you're an attorney who specializes in student loan law. Out of these two cases, is there one that you think has a better shot of winning opposed to the other?
Even before the court hearing, I think there was general agreement that the case brought by the coalition of Republican-led states centering on MOHELA was the stronger of the two. Following yesterday's hearing, I tend to agree. I got the sense that the judges on the whole were a little bit more skeptical of the second case involving the two borrowers as compared to the coalition of GOP states.
You said the judges sounded skeptical at some points during yesterday's hearing. Let's get a pulse check here. Where do you think each Supreme Court justice is leaning here?
So I kind of broke up the nine justices into three camps, roughly. There were definitely three justices who expressed the most hostility to the program in terms of how it was authorized and seemed least concerned about the issue of standing. That included Chief Justice John Roberts, Judge Samuel Alito, and Clarence Thomas. Then there were two justices, Gorsuch and Kavanaugh, who did seem uncomfortable with the legality of the program, but didn't express as much hostility as the other three justices. And they were a little bit harder to read on the issue of standing. And so it's unclear where they might fall on that. And then three justices, the three liberal justices, Jackson, Sotomayor, and Kagan seemed to be most favorably dispositioned to the underlying merits of the program, and also were very hostile as to whether the parties had standing. And then Barrett, who didn't talk a whole lot about the underlying merits, seemed very skeptical that the challengers have standing to sue. So I would kind of group Barrett with the three liberal justices on the issue of standing. And then I think it's really going to come down to the two swing votes, Kavanaugh and Gorsuch, probably on the issue of standing as well.
You've been covering this for a while now for Forbes, and in a recent piece, you said that the HEROES Act is really going to come into play here. Can you elaborate on that?
So the HEROES Act is a statute that was passed in 2003 that grants fairly broad authority to the Secretary of Education to waive or modify any federal student loan programs and provisions associated with those programs in response to a national emergency. And the Biden administration used that statute as the basis for providing this relief, saying that the national and widespread economic impact of the pandemic resulted in widespread harm, and this is designed to remedy those harms, or at least put borrowers in a place where they would be no worse off than they were before the pandemic began. The HEROES Act is central to this. A large portion of the hearing yesterday was devoted to parsing the meaning of the words modify and waive. There were a couple of judges that seemed to suggest that because Congress did not use the words cancellation or forgiveness or discharge in the actual statute, that could be a problem. But the counter argument, the Solicitor General said during the hearing, was that, look, Congress knew what they were doing, and they wrote this in a very broad way. They said waive or modify any programs associated with federal student loans, and that would include, provisions related to loan repayment and loan forgiveness as well.
Both the Biden and Trump administrations pointed to the HEROES Act both to enact and continue student loan payment pauses. Why is it that Biden's use of the HEROES Act is being scrutinized here?
Well, there seemed to be general agreement, even with the more conservative justices on the court, that it was okay for both President Trump and President Biden to rely on the HEROES Act to initiate and then extend the pause because forbearance was a program that could be modified. The argument that the challengers are presenting, at least in the GOP state case, was that this wasn't a modification of an existing program. It was essentially the Biden administration creating a new program, which is not allowed by the HEROES Act. And so they tried to distinguish what they argue is the legality of the payment pause extensions with what they're arguing is an entirely new program.
Let's talk about some hypotheticals here. Let's say the Supreme Court strikes down Biden's plan. Is there a backup plan?
The administration has publicly stated through various officials that there is no backup plan. That being said, a lot of consumer advocates have suggested that the Biden administration could, if needed, reissue the plan under a different statute called the Higher Education Act, which does have a provision as well that grants broad authority to the Secretary of Education to waive or even cancel or discharge federal student loan debt in certain circumstances. That would probably be a more difficult process. It would be longer to create a new program because they would have to go through the normal regulatory process as opposed to relying on emergency regulations. But this issue actually came up in the hearing, and there was some discussion on both sides that the Higher Education Act could provide an alternative basis for the program.
So let's talk about final thoughts from yesterday's hearing. Are you feeling optimistic for borrowers, pessimistic for borrowers, somewhere in between?
I would say I'm somewhere in between. I do think that from the borrower's perspective, from the government's perspective, the hearing probably went a little bit better than maybe people were expecting. That being said, it's still a tough hurdle here. There's a 6-3 conservative majority. The court has already struck down a number of Biden administration emergency initiatives, and those cases were discussed during the hearing as well. I think that ultimately, while a majority of the court did express deep skepticism about the legality of the program, I think that the case is probably going to turn on the issue of standing, whether the parties who brought the challenge can demonstrate an injury sufficiently connected to the program itself. And I do think that it's an open question as to how the court will rule on that issue. It's possible that if they uphold the program on the basis that these challengers don't have standing, the court doesn't even need to address the underlying merits. And that could be a way that the program ultimately survives, but we'll have to see.
Have the challengers been doing a good job so far of addressing standing?
An excellent question. I would argue that I think the government did a better job of addressing standing before the justices during the hearing yesterday. Both challengers were grilled by many of the justices about whether the challengers could actually prove that they could withstand a challenge on standing. We'll have to see what happens.
And borrowers have really been in limbo since March of 2020, when the student loan payment pause first went into effect. Now, what can they expect next?
So the payment pause it continues to go until June 30th, or 60 days after June 30th, or whenever the Supreme Court rules on this case. It's unclear at this point if that's the final extension or if it could be extended further. There were some hints during the hearing yesterday that the administration could potentially extend again. I think that will also turn on how the Supreme Court rules on the student loan forgiveness case.
Adam, you've been regarded as the national authority on student loans. So in the meantime, between now and when the borrowing does end, or the payment pause does end, or there's a decision on this case, what should borrowers do?
Well, borrowers should make sure that their contact information is up to date with all their loan servicers. They should be exploring their repayment plan options and anticipating a return to repayment by the summer. They should also evaluate their eligibility for some separate initiatives that are not being challenged right now, such as the IDR account adjustment, some new upcoming changes to public service loan forgiveness, borrower defense to repayment. There's a whole bunch of other initiatives that could be helpful to folks separate from the one-time cancellation, and it would be worth it for borrowers to look into those options.
Adam Minsky, thank you for the update.
Thank you so much.